So welcome. My name is Elva Harding, and I am a director with Contra Costa Bar Association. I'm a real estate attorney in Walnut Creek, and I want to thank you all for coming today. This is the first in our series of the law practice management seminars. And how many of you, just for interest's sake, signed up for the whole series? Great, good. So we're going to get to know a bunch of you. We're missing one of our presenters, but I will introduce Eliza, and she's going to get started, and then we'll just get things going. So this is Eliza Rodriques. She's Special Ethics and Conflicts Counsel with Sedgwick. She has more than 10 years of experience in risk management, ethics, and conflicts, and previously served as the Director of Risk Management for a large 400-attorney firm. She also has 19 years of litigation experience in the areas of legal malpractice, product liability, and personal injury. She received her undergraduate degree from Cal and her law degree from the University of San Francisco. I've heard Eliza give this presentation before. She's great. She knows all about contract attorneys. You're in good hands. Thank you.
Thank you, Elva. Hi, everybody. My apologies for the traffic getting over here, but I made it, so I'm excited. And I'll also make one correction, is that I have a new title.
Sorry.
No problem. So I'm now the Associate General Counsel and Ethics Counsel at Sedgwick. Okay. All right. Is it easier if I stand? Do that too, so you folks can see me maybe. Maybe we'll do a combination of that. So I'd like to start out maybe by asking everyone here whether you are a freelance lawyer looking for freelance work, or whether you are seeking to hire somebody in freelance. So who is working as a freelance lawyer, or at least interested in that career path? Okay, very good. And how about any folks that are seeking to hire or learning about sort of the ethics behind hiring too? Okay, great. Well, it was fun when we did this program originally for the San Francisco Bar Association for their law practice management section, which I chair. We had a good mixture of folks as well, and we must have stayed, I think, about 15 or 20 minutes after the program, and folks would exchange cards. I've already learned of some connections made, and recently had forwarded 2 resumes that I had received from that presentation, because a friend of mine, her firm was looking to hire contract lawyers too. So hopefully this will be a good combination of a networking event, and then also just talk about the freelance lawyers and how to become one, how to be successful at it, and also just the ethics parts of what you need to do if you're considering having a practice as a freelance lawyer, and also the ethical considerations when you're seeking to hire someone, because there's a lot of issues to go into. So my co-presenter, I'm going to, she'll talk more about the practical aspects. She herself is a very successful freelance lawyer. She actually wrote a book about it too, which is very impressive. So I'll talk more about some of the ethics issues on that. And actually, if you have an outline, so where I will jump in more on, let's start with some of the section 3. So how to kind of start a freelance practice, and some of the legal skills. And Marina and I have talked about this just in sort of preparation as well, because we've seen at least a good range of legal experience for folks that are looking to be a freelance lawyer. We've had some questions in the past about you have to have a certain specialty of law, and that is not necessarily so. It's very, very interesting. A lot of times if firms or even legal departments are looking to hire contract lawyers, they may not be looking necessarily at a particular area of practice, but they may be looking more for skills. So the request that I received last week from a friend of mine, and had forwarded 2 resumes, they wanted somebody that had done at least 100 depositions. They're an insurance defense firm, they've got a huge case that's coming up, and that's what they were looking for. So it didn't matter that you only have IP experience. So we're definitely seeing a little bit more of that the practical skills are something that's important for freelance lawyers. And then experienced attorneys. So again, we've seen lawyers that are coming out of law school. Sadly, I think I just read this morning in the ABA online journal that 55%, I think, of the 2012 grads have received, have positions. So of course it's, it's very scary for them. They have zero experience. So they're looking to do contract work. They've got a very uphill battle for that, not having any experience. But we try to encourage them anyway, because I think that there are things out there that if firms are looking, or even smaller firms are looking to hire, that there are work that they can do at a lower rate to the firm. Because a lot of firms, including mine, we've really decreased the size of the first year associate group. So when partners are extremely busy and looking for a first year associate to work because the client says, I'm only going to pay you this much an hour, that they're getting hard to find. So suddenly firms are looking to hire contract lawyers to fill up that void that would have been, the 20, 30 lawyer, first year lawyer class that they no longer have. So I think it's important to, one, I think to market yourself in the proper way. So if you are a first year lawyer, I think most folks now are being taught and encouraged to do more practical work even in law school. So for them, it's really trying to build up their experience if they worked at a clinic, let's say through law school, something like that. So that's more for first years, really trying to get some contract work. I think for more experienced lawyers, again, I think it's important to focus on your practical skills. You may have an interest of going into an area of law that you want to practice as a freelance lawyer too, and of course that's another way to sell yourself. And I think it also really matters what target employer you're looking for too. If you're looking for a firm that specializes in a certain area of practice, then they may be more prone to looking for somebody with that type of experience. But I can definitely say some of the bigger firms, they're looking for that practical experience for that. And then the infrastructure, I myself focus, of course, on ethics issues. And one thing that I think is important is a lot of employers for contract lawyers, they may not provide malpractice insurance for the contract lawyer. And that's extremely important to find out about that, because you'll either need to get a policy for yourself, which some of you may have already. If not, definitely ask the corporation, the company, legal department, or the firm if you would be covered under their malpractice insurance too. I'll talk a little bit about the resume. Okay. Some resumes that I have seen come in, and part of what I do at Sedgwick is that I clear all the conflicts of interest issues for all lateral hires, from IT staff up to if we're acquiring a 10-lawyer law firm. So I've reviewed lots of resumes. I've reviewed lots of conflicts forms that we have folks fill out as well. And so for me, and from what I can tell, what our recruiting folks are looking for, and then partners that make the ultimate decision about hiring, I think at one point in the legal field, and I think also in other areas, it was, folks were looking for longevity at law firms. That's gone, from what I can see. And I hope so, because for myself, I fit right into that. The general counsel of my firm started at Sedgwick when he was a first-year lawyer. Unusual, right? So he's been with the firm for almost 40 years now. I took a different path. Part of it is because I worked at Rodriques, Flagrant Harrison, which is no longer in existence. So not by choice, I had a change on my resume. And then I went over to Freelance. Yeah, another one gone. I'm amazed at the power I have, you know. And I think for freelance lawyers, it's the same thing. I mean, your resume is going to show up, you know, with perhaps a lot of different positions that you've held. And there's several options, I think, for handling it on a resume. One is, I think, the way that Marina has done it is that she formed her own law firm. So she has her firm, and she also, you know, does contract work for other firms. So her resume would have that one entry that says Modlin Legal, and then within that, she would describe to the potential employer, you know, I've done contract work, I've counsel work, and then would describe it that way. Folks always worry about having the different changes on a resume, and I just think this profession has changed so much. I remember it was probably, I don't know, early 90s. There was a partner at a law firm in, I think it was Crosby Heafy, which was around forever, right? It's now Reed Smith, I think. And one of the managing partners there, very well known, very successful, had decided to leave Crosby, leave his area of practice. It was almost unheard of, but he wanted to do something different. And I kind of feel like he really started that trend. I think folks that were in firms or in positions that felt like they didn't want a resume that had a lot of change, that really opened the door, I think, for so much more lateral movement. I think it was so much more acceptable. I think another trend is how many lawyers are going in-house to clients, too. So you rarely see, like my boss with almost 40 years at the same employer. Very, very unusual. So one thing we've got on the outline is about list under your own business name if your long-term goal is to continue your freelance business. So again, that's going to show that you've got this established practice of freelance lawyering, that you've got continuous work coming in, you formed your own practice, and that is your practice, freelance lawyering. You're not opening up a practice and saying, I want to be a family law lawyer, that's what I do. No, my practice is freelance lawyering, and these are the skills that I can provide to this future employer. So let's talk a little bit about job opportunities, too. We covered that a little, but, and again, it's sort of some of the just studies around with colleagues and other firms about what some of the trends are in hiring. And we are seeing solo practitioners that are looking for freelance lawyers. So that might be someone that wants to stay a solo practitioner, doesn't want an associate, doesn't want a partner, but they have too much work, so they need some freelance work. So I would say, if include that on part of your target.
I have a question about, and I mean this might not be exactly on topic, or maybe we're going to get to it, but about sort of solos or small practices, or even firms utilizing freelance attorneys to do admin work versus to do legal work, and where that distinction is. Because I've run across that, and or even paralegals doing legal work, and where that line is. And so I just want to know if you can talk about that.
Yeah, that's interesting. I haven't seen that. I would say in the position that I've been in, where I've either had to hire for myself doing litigation work, or even what I've seen at my firm now, and even at Zealand as well, is that lawyers would be hired for lawyer positions. I've not seen where they're doing more administrative work. That's very interesting. I would be curious to know how that's being billed out to the client and how that's covered. I think there's always been some, I don't want to say gray line, because there shouldn't be a gray line, but a little bit of a gray line with paralegals, right? A lot of it just depends on what your clients are willing to pay for, and that if you're disclosing, I have this project for you, and I'm going to have a paralegal do it. I think that's acceptable. I think I would be uncomfortable having a client hire me for something, and then using a paralegal on what I would consider more lawyer level work. And I would think the trend would be opposite, because I hear a lot of first-year lawyers that are being hired into almost paralegal level positions. because, one, they're looking for work, too. But, yeah, not administrative. And, that being the risk management person at my firm, that just like draws all these other concerns that what I would have, too. But I have not seen that trend. I'd be interested to hear. Has anyone else seen that? Lloyd's, yeah.
Yeah, a lot of people I graduated with they're attorneys and they're working for a very low hourly rate, like less than $20 an hour. And maybe they're not always an attorney doing attorney work, but maybe they're doing paralegal work. And I think it's also specific to different areas of practice. I think it's a bankruptcy mode. Bankruptcy attorneys do that. Maybe family law attorneys do that. And so in certain practice areas, it's more likely to find.
Interesting. Okay. Well, again, I think it's like any tough market that you're going to have very high qualified folks applying for maybe more low level positions. I can see that, but again, I think that you have to be clear on what you're representing to your client and your bills for sure.
You mentioned something that raised my curiosity. You said that attorneys doing administrative work raised some ethical issues. You didn't say it exactly that way. I'd be curious to hear what ethical that are different than if you hired an attorney as an attorney versus an attorney as a secretary.
Yeah, I would just be curious to know what like those administrative tasks are, and and are you telling your client that the work is legal work, and is it being billed as legal work, but yet it's really administrative?
Okay.
Yeah, that would be. I just did a presentation Friday for my firm. We have an in-house CLE program, and we did something on the ethical issues on client billing and fee collection. So much of it was about what are you representing to your client, and what have you agreed to, right? That's the most important thing. There's even some California ethics opinions about that. You for one, you want your fee agreement, of course, to be in writing, but you also want to be clear that you're giving your client proper notice about how your case is going to be handled, how it's going to be staffed as well.
Just to give an example, just so for a better understanding. So a contract attorney or a freelance attorney is hired to work on a case, a family law case, a dissolution, typical, nothing out of the ordinary, representing, husband or wife. And the main attorney wants the contract attorney to do interrogatories and everything like that, do all the discovery, fine, to make copies, to do filing, to start doing labels, to print envelopes, and it starts kind of going on. And then the contract attorney turns in the bill, hourly rate was established, all the time was kept, and then there's a dispute. Well, you weren't doing legal work, that was administrative work, but that was expected.
That was part of the contract.
And it was expected and asked for. So,
right,
and then
right.
there's this like sort of issue of like, well, what do you do? And then the other thing is contact with the clients. Direct contact with the client. You have a question, you're a contractor, you're sort of the ghostwriter.
Right.
How does that work?
Yeah, and I see where you're going with that. At least definitely the second part of it about like being a ghostwriter and not having client contact, and that's definitely something we can talk about because that does come in as the role of the freelance lawyer itself. But again, if that lawyer is billing his or her time for copying, for making whatever file labels, and I'd be curious if they're actually entering that as their description of their time, and then is that being forwarded to the client? I'm unaware of clients who will pay the lawyer rates for that, but you never know. But again, I think
it sounds to me like you have an employer who's treating a contract lawyer as if he's a W-2 employee, and I mean, as a trial lawyer, I can tell you, on the eve of trial, how many times have we all made copies and exhibits and all that kind of
No
stuff?
problem with that.
Yeah,
Absolutely.
but so it sounds like it's more of a situation where the hiring attorney is abusing this relationship.
Yeah, I would say so. And that, that's one thing that it will, I can try to cover myself, but how important it is for your engagement agreement with whoever's hiring as a freelance lawyer, right? I mean, you want to make sure. That's another topic that I deal with all the time with engagement letters for clients, is making sure that the scope of representation is really, really clear. So let's say we have let's say we have Google as a client. And so Google hires us to, to work on some real estate lease or something. Come on in. Hello, my co-presenter.
I apologize. I've spent the last 2 hours of my life in traffic, going 50 miles.
I was late too, so yes. But we're here, most important thing. So we just started talking, and this is probably a good time for you to walk in. I was just talking about your engagement letter with the person that's hiring you to be freelance lawyer, some of those issues. But why don't you talk about yourself a little bit, too?
Talk about myself, besides traffic, once I can get that out of my head. So my name is Marina Modlin. I absolutely hate being late. I apologize tremendously. I'm a founder of Modlin Legal, so I'm in my 5th year of practice, and I did nothing but freelance work for the first 2 years. Started out kind of randomly and then grew into a company. And then I got way too much work that I wanted to do and that I could handle, so I converted my practice to a full-time law firm, which is what I've been doing for the past 2.5 years, and my office is in Campbell. So the freelance side of my practice, I no longer do any freelance work, but I felt like it was such an important thing to keep talking about because it helps so many people that this is what I do very part-time now.
So we were talking, we had a great question about, let's say a contract employer hires a lawyer to do a project, but they end up also saying, here, can you make file labels, here, can you make copies, that type of stuff. So the freelance lawyer is entering that on their time sheet to the lawyer client. We were talking about some of the ethical concerns if that bill then gets forwarded to a client who's sitting here going, why am I paying a lawyer to do copies? And I was just jumping into the importance of your engagement, either if you are hiring somebody or if you are a freelance person looking to hire. So one thing I mentioned was about the scope of representation, scope of engagement.
Sure.
Right, making sure this is what I'm being hired for, and maybe even adding something that says, once this project is concluded, or if there are any additional work that's being provided, then we will put that in writing in a separate engagement. I think maybe that's one way to address that. I would definitely advise that. What are some other things that you would put in your engagement letter with the lawyer client?
Well, again, maybe I'll be repeating something that's already been discussed, but obviously I wasn't here. But on the topic of a lawyer wearing a number of different hats, as I call it, there's kind of 2 things to bring up on that subject. One of the things is I don't think there's anything wrong with a lawyer doing admin or paralegal work. But I don't think that admin or paralegal work should be billed to the client just because a lawyer is doing it at lawyer's rates. I imagine that's really something more to watch for on the employer side, because many times a contractor will not even have access to the lawyer's bills that actually get passed on to the client. But perhaps I just watch out, what kind of person are you really working for, right? But on the positive thing about wearing multiple hats, I actually discovered when I was freelancing that that's a fantastic way to get more work as a freelance attorney. Because what I learned is that, so whenever I was freelancing, I was really working for solos or small firms. So what I found out is that solos or small firms actually always have a lot of work. But the lawyers' personalities are such that if the work lands on their desk and there's nobody else to do it, they're going to do it themselves. Whereas if I kind of hang around in their face and they see me, when the work comes, they're going to give it to me to do. And obviously, as a freelancer, I was interested in getting as much work as possible. So I found for a couple of firms that I worked for that negotiating a reduced admin or paralegal rate for obviously admin or paralegal work that I would be doing would actually pay off quite handsomely, because it would give me all sorts of lawyer work that wouldn't otherwise been available had I not already been in the office to do the admin work. So I kind of saw that as a trick to get my foot in the door of the firm.
So you would suggest then that if you, I guess one, of course, you talk to your employer about what the scope of your
Sure.
work is going to be, and if it does include administrative type work, then that would be a different rate that you would negotiate.
That
makes me, my
be-
ethics hat, that feels better.
Yeah. And that would absolutely be written into my engagement letter with the attorney. And also, it would be discussed in advance that whenever a project would be assigned to me, a new project, along with the assignment, we would discuss the corresponding billing rate. So it would really, my personal invoice to the attorney, to the employer attorney, would be fragmented.
The other thing in the engagement letter, we talked just briefly a little bit about malpractice insurance. So if you have a policy that covers you, that's something that you can put in your agreement that you provide your own. Otherwise, I would definitely get it in writing that your hiring employer will be providing your malpractice insurance too. Anything else that you would advise to go into a written
Well, is
engagement
this
letter?
where we talk about malpractice insurance, or are we going to talk about that second?
We can talk. I talked briefly, but I think if you have a good perspective from your work.
So, a lot of people actually, malpractice insurance is probably, I don't know, one of top 5 questions that people ask me about. For me, when I was freelancing, I was a really new attorney, and I found that there are companies out there that offer ridiculously low rates for new attorneys that cover any type of work that the attorney does, freelance or direct client contact work. So at that rate, I think it's something like $50 a month. At that rate, I basically didn't even want to bother bringing up my employer's policy and making sure that they would cover me, and just had my own policy. I saw that as a huge investment in my own well-being, in my own law firm, and my own sanity. And actually told all of my potential employers that I have my own malpractice as an additional selling point to make it less frightening for them to hire me. I know that when we're talking about the realm of large law firms, malpractice insurance is something very, very, very complicated. And also a large firm will probably have a policy, most likely, that will cover any contractors. But I know that I want to just point out to be really careful, especially when you guys are working for solos, because solos frequently have a policy that specifically excludes anybody else's work. So if they have a small firm, maybe their policy will cover contractors. For solos, half of the policies do and half of the policies don't. So if I were practicing without my own policy, I would probably ask to actually see theirs before I did any work.
That's great. Does anybody have any questions about that engagement letter? No? Okay. I do want to go back to your other question about client contact. I thought that was important too. So, I mean, I can speak at least for big firms when we hire contract lawyers. And we hire different types of contract lawyers. So we have contract lawyers that are on an annual type of arrangement. But they're still, they're called contract lawyers, maybe not out necessarily to the public. They'll be on our website. And we'll get into some of that area as well, because that's risk management and ethics concerns about that. But I mean, I can see, and I've seen, where because there's always that competition for clients, that sometimes you'll definitely see lawyers that are hiring contract lawyers that will make sure that that contract lawyer has no communication with their client, because they're afraid of losing that client, right? If this contract person does a great job. So I could see that, but there will be instances when if the trial lawyer they're working with is in trial, and you've got some motion that you're drafting, and you've got a contract lawyer out doing that. They've got to get an affidavit from the client. You're in trial. It's almost like you do have to relinquish a little bit of that control and have confidence that this contract person is the right person that you hired, and it's not going to lead into some poaching of clients down the road. But I guess you never know. But it can be an issue. It always goes back to, I think, our obligation always to provide the best service to our clients. And here, who is your client? Well, your client is, one, the lawyer that's hired you, but two, and I think for the rules of professional conduct and our ethical obligations, the client is the client that you're actually doing the work for. I would advise if you come into a situation like that where you really feel like you're impaired on providing the best work that you can, that I think I would approach it with the employer lawyer and say, I really need to speak with a client about this, maybe make an arrangement to do a three-way phone call, I don't know, something. That's what I would advise. How would you work with that if the lawyer's like not letting the contract lawyer touch the client, talk to the client, but yet you feel in your project that you're hired for that you really need that?
Well, I think it's basically your obligation to your employer to do as good and competent of a job as possible. So if you need client contact in order to provide competent service to his client, it's really in his best interest to give you access to that client. And if I was in the contract attorney's shoes, right, and I had to do a project and I wasn't given access to a client, if I truly felt that I needed that client access to do a competent job, I would probably walk away from the job and not put my name under any work product that even I myself don't feel rises up to a level of competency. Right. And again, this would be kind of a similar situation to probably the lawyer who's billing out a person with a bar admission at however many dollars an hour for admin job. I would just question who I'm working for at that point.
I think maybe we'll just continue on with part 5, the hiring freelance lawyers. We talked about the terms of engagement. We talked about the job description. So offer letters and contracts, that's something that I mentioned too, because if you're the employer lawyer, right, it's important for you because you're also hiring somebody that you want to make sure the terms are agreeable for your work as well. So I think Marina, you usually advise, I think that the freelance lawyer draft the contract, right? I remember that from last time. Or maybe you just, most instances, you drafted your own?
In my freelance practice, in my law practice, I prefer to be the drafting party, unless I can't get away with it. I find that taking the time and using my own resources to draft something is in my own interest. So so I guess my number one preference is that I drafted something and my employer lawyer signed it. My number two preference would be they drafted something and we negotiated, got it acceptable, and then both parties signed it. And the least preferable, but also doable if the work is lucrative enough for whatever reason. I know I've worked for some people that refused to sign anything. And I kind of pushed and pushed and pushed until I saw that it's either the work is right here and the money to pay me is right here, and I can do it but have no paper trail, or I can just walk away from the job. So at that point, the work for me was lucrative enough that I accepted the attorney's idiosyncrasy that he didn't want to have a paper trail and just did the work, and it all worked out. But it's really a judgment call.
I've got something on here. It's called limited scope projects. And that is something, a lot of times, of course, with a big firm, we've got this big form. It's our conflicts disclosure form, and there's about, 10 practice questions. Have you ever been adverse to insurance companies? Because we represent a lot of insurance companies. Or some of those sort of basic ones. Have you ever filed for bankruptcy? Have you ever been sued for malpractice? Those types of questions. And then you've got to go through and you've got to provide, let's see, going back 5 years. So every client you've represented, every matter you've worked on, every adverse party or potentially adverse party or other party, and then the the date, the time frame of your representation, and also a sort of a little description about the type of work that you did. So that's something that we require from any hire, whether you're a contractor or not. And then that goes into, we have a business center, we've got about 10 conflicts analysts that enter this into our system, and then we have a legal key program that spits out these reports, and I get to review them and clear conflicts. So one thing we did, because a lot of times when freelance lawyers or conflict lawyers are needed with larger firms, they're needed yesterday. I was just on a call on my way here. We need somebody to start Thursday. I don't even know who the person is yet, but they're coming from an agency, and then we have one day to do everything. You know, clear their background check, clear the whole thing. Okay, well, you know, we can work on this. There's something that I've developed, and it's called a limited scope project disclosure form. So what, and I advise this person at my firm to do is, once we know who the person that's coming from, I think it's from an agency, then let's find out what work that this person will be doing. So let's say that the partner is working on a trial. So this freelance lawyer will only be working on this one trial for this one client, and the adverse parties are X. So what we do is, rather than have this huge form completed, is a very short form, and we'll put the parties, again, with the, you know, it's okay to disclose them, first of all. Maybe make sure with the person that you're working for, or if you're comfortable with disclosing that. So the form says, have you ever been adverse or represented? We would put our client, we would put our opposing party, we'd probably put opposing counsel, and then they would have to respond yes or no. So rather than for them having to go back 5 years, and hopefully everybody's got Excel spreadsheets that they're keeping all their information on. No? Okay, we'll get into that too. They'll just have this small form where they can say yes or no. If it's yes, I've been adverse to your client who's in this trial, we, you know, probably conflict it out. We might need to know a little bit more information. But that's one way to clear conflicts in a much quicker matter than the normal course. The other thing I've got down, so setting policies and procedures. And this kind of goes back to the question, you know, do you treat your freelance lawyer that you've hired as an employee in a way, or is it truly going to be this, you know, freelance person? And some of the things to consider on that, and this goes to the risk management, are they going to use your email account, right? Are they going to have access to your online document management system? Are they going to be on site? Are you providing an office for them? Login, I mean, all of that type of stuff. With this limited scope person, typically they will not be given an email address through the firm. They won't be on our document management system. They won't have access to anything other than this trial that they're working on. So we're able to, and we can actually, you know, limit the access that they have. So if we do want to get them into our document management system, we can electronically wall them, almost like putting up an ethical wall or ethical screen, so that they're limited. Like their access is only to this client and only to this matter. And that's one way I think that we've been able to really get freelance lawyers in the door much quicker, rather than going through the whole process, which, you know, I've reviewed reports that are 900 pages sometimes, depending on the type of work that a person has done and trying to clear conflicts for them. So depending on how you're going to hire this person and where, you know, what physical location, what access they'll have, you'll want to set some limiting policies and procedures. So again, my firm, we typically treat contract lawyers that are not for this one project, let's say. We typically treat them as if they were employees. It's just sort of a title, it's a limited time. But they're under our malpractice insurance, they have full access to our systems, they are held to our risk management policies and procedures. I just put in a parentheses about blogs, right? Some firms are Okay, if you're gonna write a blog, make sure you're not, trashing our clients. So there's always risk management things that come in too. So we would expect our freelance lawyer to also be held to those types of policies that we have. Again, so hiring fit your and your client's needs on a specific project. I mean, that's definitely something that folks will hire freelance lawyers for, because they do have a specific project. And I know a lot of times, and I think it depends on your clients, especially if you represent insurance companies, or even if you are just, if you've been hired by an insurance company to represent an insured. The same thing is that you'll want to know what their outside counsel guidelines provide. They may not, they may have to give pre-approval for anybody working on their file. So if you're looking to hire a freelance lawyer, you may need to get that approval from your client beforehand too. Something to remember. And then we talked about malpractice insurance as well. Some of the first things I think might be good, go a little bit out of order. But I think maybe the marketing and the how-to would be great if you want to pick up maybe on that. Marketing yourself.
Sure. Well, we obviously covered before freelance lawyers and the two types. We talked about that. Okay, so the marketing yourself as a freelance lawyer and the how-to of the freelance law practice, those are, I suppose, my areas of expertise. So as I said, I did build the business, and I did this very successfully for 2 years, and actually ended up writing a book that's basically a how-to step-by-step guide to building your own law practice. Well, building your own freelance law practice, right? So the outline here is really just a brief summary of everything here. I just sat down and wrote down everything that I did, because I'm a systems person, so this is all my systems. The infrastructure, again, so there's two types of lawyers, and it's kind of hard to talk at both of them in one sentence, because some are the new attorneys who are trying to explore different practice areas, who are trying to find a job when they can't find a job, who maybe are new moms and want to work part-time, that kind of thing, right? The first type. And the second type is really the more experienced attorneys who've worked the full-time job, got tired of it, found an area of law where they developed extensive expertise and which they like, and they just want to zero in on that. So I'm obviously talking more to the first type of attorneys, because that's what I did and that's what I had to do. So in terms of infrastructure, I'm a firm believer of one thing. The first thing is clients. Before you start about anything else, think about who are your clients and where are they going to come from and how much are they going to pay you. So just because you now have a small business, maybe you left a firm, or maybe you never were employed after law school, just because now you have a business doesn't mean that you need to fall for all the small business marketing things that are out there, right? Like hire a graphic designer to design your logo, build an enormous website, things like that. Again, logo is great, but if you have the money to pay for it, and the money to pay for it has to come from your clients. So, and that same practice, or that same principle, really goes for your office, for the location of your office, for your phones, for your receptionists, for everything else. As far as an office, so if you're doing nothing but freelance practice, your attorney clients are not going to come visit you to give you assignments. Your assignments are either going to be given to you by phone or email these days, or you're going to go to their office. So the glamour of your office really doesn't matter to anybody, so you might as well save some money and not rent a Class A space downtown. As far as virtual office, I hope there's no virtual office representatives. I think that's just kind of the biggest possible ripoff, at least for freelance lawyers, because you answer your own phone, and it's in your best interest to answer your own phone. I answer my own phone today. The reason why it's in your best interest is because these days the phone rings so rarely that when it actually does, it's actually important. So you really want to pick that up and answer it as quickly as possible. So paying somebody in, I don't know, middle America to answer your phone and take a message and then call you just so the person who's calling you can't get a hold of you for 2 hours just seems not practical. And that's really kind of the biggest sales point of virtual offices. You can get conference rooms. Sometimes you need conference rooms. But again, you need conference rooms probably if you either have your own layperson clients, so if you have a hybrid freelance and regular practice, or if your attorney for whom you're contracting is actually giving you access to clients. But if your attorney who's giving you access to clients has clients that he needs you to see, he should be the one providing you with office space in which to meet them. It shouldn't be part of your overhead, it's part of his overhead because he's the one with the clients. So again, I think you guys get the point about the virtual office. Nobody really sends mail either. You can get a P.O. box with a street address. If you really want to have a mailing address on your business card and don't want to put your home address onto your business card.
What if you have your own late clients and you need to set up a bank account or something like that? What address do you use to set that up?
Your bank's address is completely private, so just use your own home address.
Oh, but it's on the checks, isn't it? Like what
Well, I
address do you
suppose,
suggest
but
a PO box to be your business address strictly, or?
I think you are allowed to use a PO. Well, you don't actually have to have. You can get a PO box with a street address, so that people won't even know that it's a PO box. Like if you go to a UPS store, for example, they give you an actual address. But I think as far as actual rules are concerned, the only people that I can think of who do not let you use a PO box is Secretary of State for your incorporation papers. But your bank will let you use your home address. But for your checks, I mean, your grocery store checks have your home address, and you give those out everywhere. So it's kind of, I think, same thing.
I don't know if anyone practices criminal law, but if you're on any of the conflicts panels for Contra Costa or Alameda, you can't have a PO box.
Okay.
So if you're thinking about joining one of the panels,
In
that's something
county.
to consider also.
So I think here what we're talking about more is a hybrid practice. So if you have layperson clients, so I imagine if you're getting conflicts work, those are actual clients. That's not freelance work. That's basically a whole separate set of decisions that need to be made. So if you have a hybrid practice, if you do represent your own clients, you really have to make all the decisions as if you're a full-blown law firm with layperson clients, and then just use it less when you're using the resources of the people who are giving you contract work. So, but I guess what we're talking about here mostly is if you just have the freelance law practice. Does that make sense? Yeah, so what did we talk about? Address?
I was thinking the corporation versus sole proprietorship.
Yeah.
What would you recommend on that?
Well, the ultimate decision is a great legal research project, right? Because people contact lawyers to determine whether it's best to incorporate or remain a sole proprietor. So I'm obviously not here giving legal advice, and you guys are all lawyers, I'm assuming. So you can figure that part out, right, and contact an accountant and see what makes most sense for your personal situation. As far as a freelance law practice side of incorporating versus sole proprietorship is concerned, the way I reasoned was, I think the answer partially, given, in addition to the other factors, it depends on your long-term goals. So when I was freelancing, that was my long-term goal, to be a freelancer. I was not looking to actually get hired by any law firm. So my goal was to incorporate to my attorney, communicate to my attorney clients the fact that I'm here to stay and they can continue to rely on me long-term. And I felt like a great way to express that to them was to incorporate, basically, a professional corporation that was, at that point restricted to freelance law practice. I felt like that communicated to them that I'm not going to run away and abandon them once they start relying on me just because somebody made me a job offer. Whereas if the goal of freelancing is unknown, obviously incorporation costs money. So if the goal of freelancing is unknown, like you're up in the air, maybe if you get an offer, you'll take an offer, maybe you quit law altogether, it probably doesn't make too much sense to spend the resources incorporating. Also, if your goal in freelancing is actually to get that full-time job, I would probably say do not incorporate, because your goal then should be to communicate to any potential employer that you're really doing the freelancing to kind of give them a test drive, and your ultimate goal is to get a job. And dissolving incorporation at that point is a hassle.
Okay, so I'm moving off of this topic to the one that is really interesting to me under infrastructure, and that's billing rates.
Mm-hmm.
And so I don't know if you were going to cover that. If you're not, anyway, I just
Okay.
would really love to hear what you have to say just in terms of like how you set your rates, what you're seeing out there in terms of trends of rates, and then the alternative to the hourly rate.
Okay. Any questions before we leave the incorporation thing? Are we good on that? That makes sense.
I was just going to mention that we talked a little bit earlier about your resume. I think that's a good point, because you're either going to put your firm that you've
Right.
incorporated or you've set up, so whatever you've done,
Absolutely.
as a way of showing, this longevity, what you've been doing. Or I thought you brought up a really good point. If your ultimate goal is to get a full-time position, then perhaps you wouldn't want to look like you're not really looking for a full-time position.
Yeah.
So I'm really glad you brought that up.
Mm-hmm. Absolutely.
So rates.
Okay, so billing rates. This is my favorite lawyerly answer. Billing rates depend.
Well, yeah.
And billing rates depend on an enormous number of things. So what you as an individual freelance attorney work for just completely depends on your situation. So for the brand new attorneys that I talk to who have zero chance in hell of getting a job and have no experience, I generally tell them, if you can afford to work nearly for free, work for nearly free. Because for them, the experience, the line on the resume, and the relationship is a lot more important than sufficient living wage, provided that they have money to eat, obviously. Now, as you get less desperate in getting the work, your rates should and will go up. Because at that point, you'll be able to afford to walk away from something if it doesn't pay you enough. But especially for the new attorneys freelancing, I cannot stress enough the fact that at that point, it's really not about money. So long as it's not offensive, and so long as, again, you have something to eat, it's really not about money, and the experience and the relationship are worth any most glamorous freelance lawyer rate that you can possibly imagine. For the type 2 freelance practitioners, obviously the experienced ones with many years in the area, charge whatever you can get away with. Because you know what your time and expertise is worth. You know how much you're being billed out for, and you know that you definitely add value to the firm from the moment that you step in, right? Because you're picking up the stick and running with it, kind of thing. But if you're in a less determined position, then determining the rates, I think, is primarily a balancing act of kind of what can you live with versus what can you get away with, and somewhere in the middle, and considering the full value of the experience for you.
Do you have, a few years ago, I was doing some contract work after coming out of being a stay-at-home mom, and so I did all this research. I went out and informationally interviewed people, and I kind of found that there was a heuristic at that time, a rule of thumb, that it was about, that I could bill out at about that I could set my rate at what I thought my hourly rate would be billed out at would be 2.5 times what I would bill the employer. And I'm just wondering, and it seemed to work pretty well, but that was 4 years ago. And I'm just wondering.
Honestly, when I first started practicing as a freelance attorney in 2007, I was able to actually get $75 an hour at least from all of my clients. When I decided to look for maybe more clients in 2009, it was pretty much impossible to get freelance work at $35 an hour. But in my experience, so we didn't do my regular introduction spiel, but I'm a huge believer in relationships. So all of my businesses have been built on relationships. And it is absolutely my experience that the better relationship you have with the attorney who's giving you the work, the less money matters. So if you're somebody walking in from the street that they don't know, they're going to pay you as little as they can get away with, right? Especially if they're a small firm or a solo, because everybody is struggling. And the lawyers are not making the money that they used to make, large firm or small firm. Whereas if you have, if you've been working with this person for 15 years and they value your work and you know that you're going to add value immediately, then I'm sure the 2.5 or even more will still go even in 2012 and in this economy.
Yeah, I would agree with that. I don't think I brought it with me, but if anybody's interested, there was a really good article, fairly recent, last few months, about contract lawyers and about the benefits to the, the firms that are hiring them or the in-house legal departments. And it talked about some information about rates and like the overhead, different things like that. If anybody wants it, just let me know and I can email it to you. But I think one thing that is important, I think, obviously doing the research on it, because what I've seen is it really depends on what you're going to be working on, right? If you're going to be working on IP matters or something where partners and firms are billing out at $1,100 an hour, clearly I would definitely ask for more money for that. So I think where you're being hired is important. If it is a sole practitioner versus a firm or even an in-house legal department, but also the type of work that you'll be doing in the practice area. How much expertise are you being hired for? If you're being hired because, my friend needs somebody to take depositions for the next few months, I think it's just a little different. So I think doing your research is the most important thing. But also, and just for myself, when I've hired people, it's a negotiation, right? It's when you're looking to find a full-time position. Who puts the number on the table first, right? Is it your future employer or is it you? So it's contract negotiations.
I think you said something really important. Your friend who's looking for a depot attorney for 100 depots or whatever, those are probably contingency cases. So this whole discussion about hourly rates and 2.5 times might not be applicable.
That's very
because
true.
The lawyer can end up eating your fees.
Mm-hmm. Yeah, absolutely. And one thing I wanted to mention too, I'm glad you said that is just like alternative fee arrangements too, right? That's something that I see from our end with our clients, institutional clients, whether we're going to do something on a flat fee basis. That might be something that you want to negotiate. If it might be in your interest and your lawyer client's interest as well. If you know it's a project and it's going to take 15 hours, they want you to draft something. Maybe don't do it hourly. Maybe just do a flat fee, and then you've got your hours. And then if it's added work to that, or if they suddenly add another issue to your brief, put it in your engagement letter. At that point it's going to turn into an hourly rate, right? So it truly is like negotiating your contract. What you're doing.
I'm seeing more and more law firms moving away from billable hour, and obviously more and more clients openly hating the billable hour. And when cash flow is an issue in small firms, a runaway freelance attorney is, as a small firm owner right now, that's probably my worst nightmare. That person could bill away my entire next month's rent. So what I do is I'm certainly always more inclined to bring in contractors that are willing to do flat fee work. And now that said, if I have the relationship with the freelancer, and now I'm speaking from the employer side, right? If I have the relationship with the freelancer and I know that they're going to add value from the get-go rather than require 30 hours of training, before they produce something that I could possibly bill to the client. So if I know that they're going to be valuable from the beginning, and I know that I have a client that will pay, right, then I can do an hourly rate. But even with people that I know, whenever I do hourly rate, I'm really strict, and I learned this probably from the first or second freelance attorney that I freelanced for, right? For every project assigned, be really strict about finding out what the time expectation for it is. And then take maybe 30% of that total time and make that a mandatory check-in time. Even if you have a supervising attorney that really is not communicative and really doesn't like to answer emails and pick up the phone, just make it your own freelancer personal policy to not proceed further until you get a check-in and kind of a, you know, a gold star that you are in fact on the right track.
I was just going to say, I think that's like such important advice, because I had a job where the attorney gave in what I considered unreasonable time limit, didn't check in with the attorneys, and ended up spending 40 hours, got paid for 4. And I mean, granted, this attorney repeatedly gave an unreasonable time limits, but also if I had checked in after those 4 hours or whatever, maybe it would, I mean, for sure it would have condensed the amount of time, but also it might have narrowed the issues.
Because you were probably not really on the right track.
Well, it won.
So
at least it won. So at least she was happy with it, but it was consistently, she said 3 hours. Everything takes 3 hours. Everything took 3 hours. Doesn't matter what it was, it always took 3 hours.
The answer is 47.
So I think that's really important, and I like the idea of it being the freelancer's responsibility to go in and check in and say, like, am I on the right track? I spent X amount of time. You said it would take 3 hours. It's been 3. Here's what I've made.
I actually wrote that into my engagement letter. So basically, I made them read that and sign to that this is what they're going to do. And it was really awkward because some of them just didn't want to hear about it because, you know, they assigned the project to somebody else. Why should they think about it? And another important thing to note, again, this is the balancing act about, you know, how badly you need the work versus how badly you need the money, is that as a new attorney, you certainly will, and I believe should, eat some of your fees. Because it's ultimately in your best interest to get more work, basically. So I don't know about the 36 hours, but
I work with a small firm, and we have an arrangement where with them I'll accept you know, half or whatever the proportion is of what they actually collect on my time. I wouldn't do that with everyone because you have to trust them, because they're obviously going to be tempted to, you know, squash down your hours. But where you have someone you actually trust, it kind of puts you on the same page if you're willing to accept just what they can bill and actually collect.
I would, it's interesting, I would probably be more worried not so much that they're going to cut your hours because that's good for them, but I wouldn't trust their collection practices. And really, the ability to collect is one of the hardest parts of running a law firm.
Right.
And I think that should be part of their overhead rather than your risk. So I think if you are in fact nice enough and have a good enough relationship with them to do that, you should market that as your selling point. Like, that's one thing that I'm giving you, kind of thing.
Yeah, and I did. And in their case, they're really good at it because they don't charge that much, and I trust them. I wouldn't do that for most people.
Yeah, exactly.
It can
Again,
work out.
relationship.
Yeah.
There was one question.
I just wondered if you could just take a couple of minutes to talk about setting of a flat fee. I mean, I think one of the reasons why we all kind of fall back on the hourly rate is that if you can come up with some reasonable estimate of your hour, what your hour is worth, well, then it's a simple matter of keeping track of the hours. Whereas if you're going into, particularly if you're relatively new to an area of practice, if you're going into that, do you have any thoughts on how?
It's a matter of figuring out what the client can be billed. So ultimately, the billable hours worth is the law firm owner's decision. I completely agree with you. I mean, it's a huge risk to take flat fee arrangements as a freelancer in a practice area where you're not very up to speed. But at the same time, because you're very not up to speed, I think it's the freelancer's responsibility to get up to speed, however long that takes. So I think the first few times, I mean, I think it's totally reasonable when the project is first put on the table to spend time and get as many details about the project as possible, and then ask for 24 hours to go do your research and say, then I'll come back to you and give you a flat fee. So I think I think it's your responsibility to do due diligence on the flat fee, but especially if you're new, the attorney shouldn't be paying you to be learning this, because the attorney ultimately only cares about, the attorney obviously knows how to do this particular project and knows what they can bill their client for it.
Yeah, I've also seen, rarely, but some smaller firms that have freelance lawyers on like a monthly retainer. So basically they'll pay you, I don't know, $20,000 a month. And then like you're their freelance lawyer. You might work a 10-hour day, you might bill a 3-hour day, but that arrangement is a monthly flat fee too.
And that's kind of more like a salary though. And then of course you bill whatever you bill, and then the attorney cuts those hours and passes those on to the client. Yeah.
But I think, I mean, I myself have not negotiated a flat fee, and I don't know, as a freelance lawyer, I don't even know where I would start. I mean, I think for me it would be so critical with that engagement letter, again, being so discreet about what you're doing for that flat fee, and perhaps including things that are excluded in that flat fee too.
We talked a lot about the engagement letter and how important it is, but my question is how do you enforce the engagement letter when you're really at, and I mean this is pretty obvious in this market, that if you are a contract attorney, you're at, or what did you call it, freelancer, that you're basically at the will and whim of these attorneys, mercy, one might say, of these attorneys. And so you've got this great idea, you lay it all out in this letter, and it all sounds like it should be good. But enforcing it, and ultimately, like you said, it's about relationships, so you don't want to burn your bridges. And compelling them to abide by those terms.
Well, it's better than not having that piece of paper.
I'm just wondering if you have an idea about like how you might handle it if those terms are not honored.
Well, I guess that really depends on the damages, just like enforcement of any contract, right? That's the analysis. I mean, I suppose you could take it to small claims court, or you could just forgive them the $2,000 that they didn't pay you because you know that you're going to get $30,000 more of work from them in the next year.
Do freelancers ever negotiate a deal like a law firm does, where they'll take a retainer and then they'll bill against the retainer, and it has like a fund that gets replenished over time?
It's all a private agreement. I mean, you can negotiate whatever you want to negotiate. Yeah.
At least there's a pool of money there that you can draw.
So I think that goes back to, I hate to keep repeating this, it sounds really harsh, but how desperate you are. Like, if you are fine without the work, you know, if you can afford to negotiate yourself out of that work, basically, then you can demand whatever. I mean, you can demand, you know, a retainer that's worth a year's worth of fees up front, right? And just wait for the client that takes that.
And this is, I'm not trying to be argumentative, but this has just been my experience, that if you accept less, they're going to continue to pay you less. And if you do the work that's admin work, they're going to continue to expect that work. And that, you could eat it, you're right, you could eat that $2,000 fee, but next time they're going to cut and they're going to expect. So, and I don't think it's just one attorney. I think I've worked in lots of different kind of areas and for different attorneys, and so my curiosity is how to be reasonable. And of course, everyone makes copies. I have no problem making labels. I love labels. Right. But it's like, how do you know?
Well, so when I worked as an admin, I mean, I literally had an admin job. Before I signed that agreement, I said that my admin work is going to be capped at 15 hours a week. And I could quit that job just like any other admin. And I actually ultimately ended up quitting that job, and they ended up hiring an admin, and everyone was happy. So, I don't know. In my experience, they don't, if you start out, now, I mean, if you're a 9th-year attorney coming from a huge law firm with one practice area, and you're continuing to do that same practice area, and you're willing to work for $25 an hour, probably there's something wrong, and there's probably something wrong with the person that's hiring you. But if you are reasonable in your fees, right, in my experience, if you're reasonable in your fees and you're doing good work that is actually profitable to the attorney or the firm that's hiring you, they're not really going to look to take advantage of you. And another reason to have an engagement letter is to put a term into it. Say that this engagement letter is valid for 3 months or for 6 months. That gives you a totally natural renegotiation point.
Yeah, it all comes down to contract law. I mean, right? That is, and relationships.
That's the touchy part is that you're not, these relationships, you want to get hired by other attorneys, you want that word of mouth, those referrals.
Right.
But you also don't want to feel like.
But the thing is, your first attorney for whom you're going to be working, and maybe you've never done this type of law, so you have zero experience. So you take this job for the sake of the experience and you're horrendously underpaid. When that attorney is going to refer you to his old Hastings classmate, they're not going to be discussing how much money you make, in my experience. Or you can ask them not to.
That's another question.
Well, I think you should also keep really good records of like how much time you spent and what the project was, what it was, you know, maybe even store a copy of it just as a proof, you know, not for poach their clients or whatever, you know.
Absolutely.
And maybe redact that if you're scared that, oh, you're keeping files on your own personal computers. And then maybe even have a conversation with the attorney and say, like, look, this is actually what I'm looking to do. I don't mind doing the admin work once in a while if you're in a pinch. We have to file something late the next day and it's your last minute. But really, I want to do this kind of work more or something like that. You know?
Yeah, having that open conversation, definitely.
Because then I think they will step all over you. Because they don't know what you want. They go, oh, you're okay. It's the market. It's the market.
Yeah, never play for the I mean, they're aware of that. Be aware of that too.
Exactly. A couple more questions? Sorry.
Yeah, I actually have a comment.
Yes.
And I think that part of the thing that you were talking about is being strict about where you are in the project. And let's say that somebody gave you a project that they said was 3 hours.
Right.
And, well, nothing takes 3 hours. But I think that part of it has to do with your reputation as a contract attorney.
Yeah.
I work with contract attorneys. And I feel that, at least with one of them, he's captain. I depend on him. So I'm sort of tied to him because he is so good at what he does that I don't have to worry about it. On the other hand, there are, I've run across some people that I would really rather, that I would never refer to somebody else because they dropped the ball. And really, if this particular person that works for me was to ask me for something else out of my practice, I would certainly give it to him because I know that I'm in good hands when that individual is taking care of that particular kind of work. So whereas some people might feel that you're expendable, yeah, we're all expendable, but some people you don't want to expend as quickly as others because my own survival, at least my profit survival, depends on the ability of people to uplift their reputation as they're the person that you want to be able to pay that money that you can pay, and other people not.
Before we get off this topic, my comment is reputation works 2 ways. And if somebody's not paying you, this is with everybody, right? If somebody's not paying you, if they're not on time with their checks, if they're being, it sounds like you got a real done. Hopefully it's only one, right? So if anybody's treating anybody else like that, hey, their reputation is at issue too. And there are attorneys that I know of, and everybody knows they do not pay. Can you go do this appearance for me? Nope, because you're not going to pay me.
That's a great point.
And you're a freelance, so you're free to go.
Yeah, it's a little different obligation with the client, definitely. I know
we're out of time.
We are out of time.
And so I'm sorry to interrupt, but I don't know if you guys can stick around for a couple of minutes to take some questions.
Traffic won't die for 2 hours.
Right, traffic's going to be there. Thank you all for coming. I want to remind you, July 17th is the next seminar, Setting Up a Virtual and Mobile Law Office, and we'll be in this building.
Oh, yes, in this building, but
down the hall, same floor. Okay? Thank you all.
Okay. Thank you. Anything on the outline?